Hello everyone, welcome to another interesting and informative session of the Analyst brought to you by Vajiram and Ravi. In today's video, we will discuss 5 important topics as featured in the Hindu and Indian Express for your larger understanding of the current affairs. The topics are as follows. In the first article, we will read about right of person with disabilities in our country and various issues being faced by them. Then in the second article, we will inquire about the Medical Termination of Pregnancy Act 2021. In the third article, we will read about the issue of tax evasion being faced by our country and various steps taken by the government. In the fourth article, we will read about the European State of Climate Report, and then in the fifth article, we will read about the Operation MEGHDOOT, which has recently been in the news. Towards the end, there will be news snippets especially curated to help you excel in the upcoming prelims examination, so stay tuned. Several political parties has promised in their election manifesto to include disability as a specific ground for discrimination which are prohibited under the Article 15 of the Constitution. Thus, the right of person with disabilities and various issues being faced by them forms an important component of your GS1 paper under the larger theme of social issues. So let's first try to understand who exactly is a disabled person. Well, as per the definition given by World Health Organization, disability is an umbrella term encompassing impairment, activity learning, or participation restrictions which are considered normal for other human beings. Thus, according to the Government of India, which has enacted the Right of Person with Disability Act 2016, it lists down 21 different types of disabilities. And it also provides for benchmark disability, which is basically a person who has at least 40% of any specified disability as certified by any government authority. Thus, according to the Act, it defines locomotor disability as people who have been victim of acid attack or patients of leprosy, polio, etc. or intellectual disability such as learning disorders, for example, autism. Now, according to the census of 2011, in our country, there existed 2.68 crore people who were suffering from one form of or another of disability, of which 1.5 crore were male and 1.18 crore were female. But according to the World Health Organization's recent estimate, this number has significantly increased to 4 to 8 crore people. Now, these people who are suffering from these disabilities, they face several challenges which undermines their dignity, their self-confidence and compromises with their basic human rights, such as the persisting social stigma which arises due to the existence of limited awareness among the larger section of the society about different types of disabilities which exist, where these disabled people, they are termed as mentally retarded, crippled or wheelchair bound. The existence of such social stigma was gravely depicted in a very famous movie called as Tare Zameen Par, where the protagonist of the movie, Ishan, was actually dyslexic and thus he was unable to read and comprehend like other students. And his parents, showcasing the social stigma, they actually did not realize the impact of such serious health issue and punished Ishan for considering this issue as the act of negligence. Then this issue is further compounded by the existence of exclusionary system, which is depicted from the report of Center for Research and Planning of Supreme Court on the district court complexes, where it found out that only 50% of such complexes, they did not had any ramps. Only 25% had the availability of wheelchairs and only 5% had tactile paving to assist a visually impaired person in the court, thus making these disabled people constantly relying on external support for basic human activities. which ultimately translates into loss of their dignity, independence, and privacy. To understand which, let's say you put yourself in the position of a visually impaired person and you want to go to the nearby supermarket to buy toaster. To start with, you go to an online app to book the cab ride. But because that app is not accessible for you, you seek an external help to ultimately book the cab. And when you reach to the supermarket, there is absence of any tactile pavement there, and thus you need external help again to reach to the electronic appliance section. There the product, it does not have any braille reading method, and thus you are unable to gauge the cost of the product, so you will ask for the help again. Thus, this constant reliance on external support actually undermines the self-confidence of the disabled person and undermines his dignity as well. And now, as your consumer choices has been exposed to other person, it ultimately violates your privacy. Now, according to the World Health Organization, many of such disabilities are actually preventable, such as disabilities which are caused due to the issues which were faced during the birth time or during the pregnancy time, or the disabilities which are being caused because of the issue of malnutrition. But these issues are further compounded and aggravated because of the existence of the poor state of health infrastructure in our country, which ultimately leads to these disabled people does not have access to accumulate social capital, and thus they have a poor access to education, which is reflected here from the 76th round of National Sample Survey data, which was released in 2018. According to which 49% of these disabled people were actually illiterate in comparison to 24% of the people who does not face any kind of disability. Now, because of such low accumulation of social capital, it ultimately translates into the high level of unemployment, which can be seen here that almost 76% of disabled people were unemployed, and even if they got employed, they got such job in meager sectors such as cultivator, agriculture laborers, or in household industries, which ultimately leads to their economic deprivation, which is further exacerbated because of the high out-of-pocket expenditure due to poor public healthcare infrastructure in our country, and because of the over-reliance of these disabled people on medical support, to buy some support tools, etc. Thus, according to the World Health Organization, an average disabled person spends rupees 2,477 monthly on their healthcare. Then, as per United Nations Convention on Rights of People with Disabilities, this section forms an invisible minority, where there exist 1.3 billion people globally who suffers from one or other kind of disability, almost equal to the population of our country, out of which 80% resides in developing countries and 70% of them are actually confined in rural areas. Then such invisibility further exacerbates due to the political or governance decisions. For example, the government of India recently decided that it will not include any disability specific questions in the National Family Health Survey of 6th round. Then, as we know that the climate change which is taking place, it can actually compound the issues which are being faced by these people, as they are more prone to suffer from the global warming, heat wave, cyclones, droughts, floods, etc. And because of these issues, these disabled people, they are constantly being deprived of their basic human rights. Thus, following the constitutional directive under the Article 41 of the Constitution, which directs the state to provide for public assistance in case of disability, there has been several steps which has been taken. The first was the adoption of United Nations Convention on Right of Person with Disabilities in 2006, which was ratified by India in 2007. Then the Government of India enacted Right of Person with Disabilities Act 2016, the major provisions of which you guys can see on the table, where it provides for right to equality, accessibility and reasonable accommodation to these disabled people. Then under section 3, no person shall be discriminated on the ground of disability. Keep this in mind that this is currently a statutory right and the demand is being raised to make it a constitutional right. Then it increased the quota of reservation for disabled people in government jobs from 3 to 4% and in higher education from 3 to 5%. Then it also provided for right to free education to every child with benchmark disability, which is a specified disability up more than 40% between 6 to 18 years. Then it appointed for a chief commissioner for people with disability to act as a regulatory body over the grievance redressal agencies. It also created a separate national and state funds for the improvement of the condition of people with disabilities. Then it also provided for penalties which will be charged for any offences which will be committed against such disabled people. And to foster adjudication of such cases, it also establishes special courts. Then the government has also launched an Accessible India campaign or Sugam Bharat Yojana, under which the government is providing for ramps in public places, accessible transport, tactile flooring in the public places, as well as sign language for hearing impaired people at public places. Then the government has launched the Deen Dayal Rehabilitation Scheme, under which funds are provided to NGOs who are working for the betterment of disabled people, such as creation of special schools or early intervention in the childhood itself, or providing for medical facilities to these people. Then the government has taken several other steps such as ADIP, under which the government provides the accessible technology aids which are modern in the future and they can help these disabled people for their better communication, accommodation, their further transports, etc. Finally, the government has also launched a unique disability ID card to provide for these disabled people for further collection and dissemination of data at various government level agencies. Then there is a Spark project which is being implemented by International Labour Organization and International Fund for Agriculture Development, where these disabled people are trained as disability inclusion facilitators to act as a role model for community participation. Currently, this project is being implemented in the state of Maharashtra. Then there is a GLAD network which has been created by UNESCO and India is part of it to further disseminate awareness among the larger section of the society for various kind of disabilities, to increase the coordination of their disability inclusive contributions and to expand and diversify the community of partners who are contributing the resources to such disability inclusive development. Then there are certain local initiatives as well, such as taken by the Chhattisgarh government, which nominate at least one disabled person in each panchayat, thus increasing their participation in the political sphere as well. However, there are several other steps which shall be taken, such as increasing awareness through community participation, through organizing of cultural events, such as through use of mass media, which was done by Tare Zameen Par movie. Then, as the article suggests, there is urgent need to include the discrimination against persons with disabilities as a ground under Article 15. To provide them with constitutional right. Currently, Article 15 prohibits discrimination on 5 grounds, which are race, religion, caste, sex and place of birth. Now, on the basis of this discussion which we have taken, try to solve this previous year mains question and we move forward to the next news of the day. Exercising its power under Article 142 to do complete justice, the Supreme Court recently allowed a rape survivor to terminate her 30-week pregnancy. Thus, the laws governing the termination of pregnancy in our country forms an important component of your GS2 paper under the theme of government policies and interventions. So let's first try to understand what is India's law on abortion, which is governed by the Medical Termination of Pregnancy Act 2021, which amended and replaced the existing MTP Act of 1971. The MTP Act of 1971 only allowed for termination of pregnancy up to 20 weeks by a married woman only. However, this provision has now been changed by incorporating the unmarried woman as well, thus creating a liberal provision. Then, the termination of pregnancy is allowed from 12 to 20 weeks on the advice of one registered medical practitioner, and from 20 to 24 weeks on the advice of two doctors for some special categories of women under Section 3B of the Act. And such special categories of women include survivor of rape, victim of incest, any vulnerable woman such as mentally disabled person or a minor person, etc. Or if there has certain change which has taken place in the marital status during the pregnancy. The Act also provides for prevention of privacy as it prohibits the disclosure of the identity of the person who is undergoing the termination of pregnancy. However, despite such liberal provision, there exist several persisting issues which undermines the termination of pregnancy, such as the limitations beyond 24 weeks. For example, the Act, it only allows that the termination of pregnancy can take place after 24 weeks in one condition, and that is when state level medical board will diagnose any kind of substantial fetal abnormality. Otherwise, the abortion cannot take place after 24 weeks. Thus, let's say that if there is a survivor of rape and that person wants to abort her pregnancy or unwanted child after 24 weeks and the state level medical board does not allow for do so, then the only recourse which she has is to go to the court under the writ petition. Now, such woman is already facing a lot of trauma because she has become the victim of the fate, because of which she is facing social stigma, societal pressure, family pressure, etc. And they do not want to get involved in any kind of such court cases through writ petition and all, and thus such provision actually enhances the psychological impact and further create the issue of either unwanted child or maternal mortality. Then, according to various health experts, such limitation of 24 weeks actually act as the violation of right to body autonomy, which is considered as an integral part of right to personal liberty under Article 21 of the Constitution. Then, as per the Act, it allows that such abortion can take place only by a specialized doctor who has got a specialization in gynecology or obstetrics. But as we can see from the data here, there exists a huge shortage for such certified doctors in our country, thus leading to the issue of lack of accessibility to safe abortion. Whereas we can see the data from the news, there take place 7 million abortions in our country, out of which only 50% of these operations are legal. And 8% of women who opt for such abortion die due to the complications which arises from unsafe procedures. Then there exist different interpretations of fetal viability. Fetal viability is basically considered as a time period after which the fetus can survive outside the womb. Thus, now it is considered to be alive. Now, there are different interpretations that what exactly forms the time period of such fetal viability, because according to some health expert, it is 28 weeks, but due to the recent scientific advancement, it has curved down to 24 weeks or the period of 6 months. And that is exactly considered as the time limit under the Indian Act as well, thus giving the birth to the ever-going debate, that is pro-life versus pro-choice debate, where certain people vouch for body autonomy as, according to their argument, the abortion of pregnancy shall be the sole right of woman, as it is the part of her body autonomy under the right to life or under Article 21. The argument was supported by the landmark Roe vs. Wade judgment of US Supreme Court, where it provided for the constitutional right to abortion to US women. However, keep this in mind that recently this decision has been overturned, and thus now USA has taken a pro-life approach. A similar kind of pro-choice approach was also reflected in India's Supreme Court judgment, where in Bhutan Baro versus State of Assam 2017, it vouched for transformative constitutionalism, where it said that there shall be more liberal rights provided to the women to decide on the issue of abortion, as it reflects the changing nature of the society and family structure in our country. And thus law and constitution shall also be reflective of such changes which are taking place in the society. The same approach was also accorded in K.S. Puttaswamy case of 2017, where the right of women on abortion, the right of choice, was held as constitutional right under personal liberty guaranteed under Article 21. However, there is another section of people who vouch for pro-life choice, where they says that it is actually the fundamental right of unborn child, as after 24 weeks it has become a living entity, and they consider embryo as a separate living entity from the woman or from the mother itself. And a similar approach also actually reflected in Supreme Court judgment in this year itself on 1st of February 2024, where the Supreme Court actually refused to allow the termination of pregnancy of up to 32 weeks, which was being asked by the woman, to actually protect the right of unborn baby. Now, there are several countries which has taken such pro-life choice, where the abortion is completely banned, such as Poland, Egypt, Philippines, etc. In India, we have rather chose to take a balanced approach between pro-choice and pro-life stand, where we do provide the woman the autonomy to terminate the pregnancy up to 20 weeks and even up to 24 weeks in some special cases. However, after 24 weeks, when the fetal viability has increased, then the termination of pregnancy is allowed only in special circumstances, as it was done by the Supreme Court recently. Thus, it shall be imperative for us to make sure that we provide for more safeguards to the abortion to ensure the achievement of Sustainable Development Goal 3, to provide equitable access to health to all, and to reduce the maternal mortality ratio in our country as well. And as the Supreme Court has held in Bhutan Baro case, there shall be a transformative judgments as well and lawmaking as well, which shall be more reflective for the changes taking place in the society. With these suggestions, we move forward to the next news. The article highlights the issue of tax evasion by multinational corporations and various steps which has been taken by the government of India to curb such practices in the light of the recent India-Mauritius Treaty. Now, this issue of tax evasion forms an important component of your GS3 paper under the theme of challenges related to Indian economy. So let's first try to understand the issue of tax evasion which is taking place. Tax evasion is basically the avoidance of paying taxes by these multinational corporations which they legally own to the government of the country in which they are functioning. And such tax evasion has been taking place through various channels, first of them being base erosion and profit shifting. What is BEPS? Let's try to understand that. Let's say that there exists a banana corporation, which is a multinational company based in US, and it is headquartered in California. Now it falls under the corporate tax bracket of 30% which is being charged in USA. So what it does is that it just transfer or shift its base by transferring its profit, property titles and any other major investments to a Mango Limited. Mango Limited is what? It is basically a shell company which is located in a tax haven country, or let's say a country where the corporate tax rate is low, or let's say 10%. So earlier, if this banana corporation had to pay rupees 30 to the US government, now it will just pay rupees 10 to this particular country here, thus saving the 20 rupees of profit or doing tax evasion of 20 rupees. And such base erosion and profit shifting has actually led, as per the tax evasion report of 2024, as mentioned in the article, it has led to 4% of global GDP which has been stored in such tax haven countries. And around $1 trillion has been transferred to these tax havens, which are actually equivalent to the 35% of the profit incurred by these multinational corporations. Then what will happen, that let's say I am a country A and I am not very much industrialized and thus I am not getting any tax benefit from the companies which exist in my country. Thus, I want big companies like Google, Amazon, Facebook, etc. to come and invest in my country. So what I start doing is that I start reducing my tax rate on shared profits. Thus, these companies such as Facebook and Google will now start creating investments in my country, providing for foreign direct investments, infrastructure boost, etc. And how I am going to avail this? By reducing the tax rates, which is concept is termed as race to bottom countries, where the countries lower down their corporate tax rates, such as 5% in Ireland, 8% in Switzerland and 0% in Cayman Islands. Thus, according to this global tax evasion report, the effective tax rate has actually come down equivalent to 0 to 5% because of the creation of such shell companies. Then these companies are also involving in the issue of greenwashing, where they try to earn these green tax credit, where they show that now they are transforming to a low carbon path, and by doing that they reduce the taxes which they have to pay to the government. Then there are two emerging issues. The first is of treaty shopping. What is treaty shopping? Let's try to understand that. Let's say that there is an investor named Tio, and Tio belongs to a country A, and Tio wants to invest in a country B, which say that is India. In India there is a company, let's say Army, and there they want to do the investment. Now in India there exist heavy taxes on dividends or profits which is earned by this company. Thus, if Tio is going to directly invest in this company Army, then she will have to pay a higher amount of dividend. But India as a country has signed a tax treaty with another country, let's say Mauritius. And now under this fiscal treaty, the both countries has decided to lower down their taxes on any kind of dividends. So now what TO does as an investor of US, that she invests first in a company in Mauritius. And this company is nothing but a shell company of TO. And finally, through this shell company, which has now been created in Mauritius, under this tax treaty, she will do the investment in this company in India. And now whatever will be the dividends under this tax treaty, she will have to pay less. Thus, she will do the tax evasion through this indirect route, which is called as treaty shopping. Then there is emerging issue of round tripping, under which what happens that first the profits which has been earned in our country, they are sent out through unofficial channels, and then the same fund is actually invested back in our country through official channels to further earn the dividends. Now, to deal with such major issues, the government has taken several steps. First of which is provision of equalization levy, which is charged as a direct tax of 6% on non-resident service providers on any profit or income which they have incurred on the advertisements provided. And this was introduced in the budget 2016. And under the Amendment of Finance Act 2020, this equalization levy has further increased and covers now e-commerce operator such as Amazon, Facebook, Google, etc., who have to pay 2% of equalization levy. Then, under the framework of OECD, or Organization for Economic Cooperation and Development, the government has signed the multilateral instrument, which basically provides for an option to select tax treaties with other country and to provide for swift amendments to these treaties. So now let's say if we have signed the treaty with Mauritius and some company like TO is trying to exploit this tax treaty, so we will do swift amendment under this multilateral instrument. It also provides for a principal purpose test for any kind of treaty which we are signing to check out each and every provisions so that the misuse of those provisions cannot take place. Then it also provides for anti-avoidance or anti-tax evasion avoidance rule under this multilateral instrument. Then there is global minimum tax framework which is being negotiated under the framework of OECD, or Organization for Economic Cooperation and Development, which is also being negotiated by India along with other 125 countries, which aims to provide for a subject to tax rule under which there shall be a minimum tax rate of 15% which will be applied to multinational corporations across the world. So let's say that there is a particular company which has earned a profit of 100 million euro, out of which it has to pay the 12.5% in the jurisdiction from where the company has incurred the profit. But let's say the company is Google and its home jurisdiction lies in USA. So now let's say that if the company Google has already paid 12.5% of the taxes which it owed to the country in which it was functioning, let's say India, the remaining 2.5%, because the minimum tax is 15, so it's not possible that the company will get away with the 2.5. The company will have to pay the remaining 2.5% in the home jurisdiction. Thus, by taking these measures, we have tried to ensure that the tax evasion issue curves down, which actually hampers the fiscal deficit of our country, and it leads to higher fiscal deficit and thus also hampers our economic growth. Thus, more stringent measures under the framework of Basel, OECD, as well as to create a stronger tax framework, the government has taken several steps which we have discussed about. With this, we move forward to the next news. The recently released European State of Climate report highlights the issue of global warming which is faced by the European countries and the steps taken by the European Union. The issue of climate change and its impact on several places such as Europe forms an important component of your GS3 paper under the theme of climate change and its impact. So let's first try to inquire about the findings of the report which has been released by the United Nations World Meteorological Organization and European Union's climate agency called as Copernicus, according to which Europe has become the fastest warming continent, where the temperature while for the world has increased by 1.3 degrees Celsius, for Europe it has actually increased by 2.3 degrees Celsius from the pre-industrial levels. And the average sea surface temperature for ocean in Europe is actually has reached the highest annual level in 2023, which has significant impact on the climate of the Europe, as we can see from the various cases of wildfires, where the wildfire season has started earlier each year, and there were recent cases of rampant wildfire in countries such as Spain, Germany, Portugal, etc. Then, because of the heat waves which are taking place in Europe, quite uncommon phenomena which is taking place there, it has led to the loss of life of more than 140 plus people. Also, there is taking place the glacier ice loss, as for example, the Alps have lost 10% of their glacier ice in the last 2 decades itself. Also, because of which it is taking place the lack of snowfall because of the increasing heat waves and the climate changes which is taking place, and all this actually has been accumulating and leading to economic loss, which according to the report was around 13.4 billion euro in the year of 2023. And because when such climate change will take place, it will actually exacerbate the issue of migration, where a large scale migration such as from South Asia and Sub-Saharan Africa will actually be directed towards Europe. Now, to deal with such emerging issues, the European Union has taken several steps. For example, under its revised targets of Paris Agreement 2015, the Europe is trying to reduce its greenhouse gas emission by 55% by the year of 2030 and to ultimately become a climate neutral country by the year of 2050. For which purpose, the European Union has launched a Fit for 55 package, where it is trying to create a EU emission trading system, where it will try to incentivize the public transport to creation of electric vehicles or the vehicles which will run on renewable energy. Then it is trying for the effort sharing regulation, increasing of renewable energy directives, such as it is trying to achieve the production of all energy from renewable energy of 40% by the year of 2030 and to further enhance its energy efficiency by 36%. Then, under the Fit for 55 package, European Union has also launched a Just Transition Fund as a part of Green Deal, where the companies who rely heavily on fossil fuels such as coal, they will be provided with subsidies and incentivized to move away from the fossil fuel sources towards greener fuels. Then the European Union is also providing a social climate fund, where it is going to fund for the creation of green buildings, to incentivize people to use public transport being run on renewable energy, as well as to fund the people or provide subsidy to the people who are most vulnerable to climate change, such as people living in coastal areas. And for which purpose, the European Union has also launched a carbon border adjusted mechanism, which has been repeatedly in the news. The reason for that is that under CBAM, the European Union is going to charge or put taxes on the import which has been made or derived from fossil fuel, and this tax can be around 20 to 35%, which is still under negotiation as a concept. Thus, as we can see, the European Union has taken several strong steps just on the line of Panch Amrit targets which has been taken by the India. However, there can be some negative effect of such steps which has been taken by European Union on our country as well. For example, under this CBAM mechanism, it will actually affect the export of various products which we do to the Europe, such as steel, iron, etc. Thus, we will keep these facts in our mind, and especially from prelims purposes, we will remember the actions which has been taken by the European Union. And we move forward to the next news. Recently, the Operation Meghdoot completed its 40th anniversary, highlighting the achievements of Indian soldiers by securing the strategic Siachen Glacier. Thus, the Operation Meghdoot forms an important component of your prelims paper under the theme of current affairs. So, what was Operation Meghdoot? The genesis of which it lies in the bone of contention which was taking place between India and Pakistan for this particular reason, and as there existed a disagreement over the Karachi Agreement, that what exactly forms the line of control. Under the Shimla Agreement of 1971, finally the line of control was accepted by both the countries, but this glacier area here was left unmarked. Now, if Pakistan would have occupied this region, it would have actually provided Pakistan a strategic connectivity directly to the illegally occupied area by China here. Thus, the Pakistan started making its claim in the early 1980s by sending various mountaineering expeditions to this region, which was actually traced by our security agencies, and they informed us before itself, and thus India started taking pragmatic steps to capture this strategic region. The first of which was the expedition led by the Colonel Narinder Bull Kumar, which helped in mapping of this region efficiently, and ultimately the Indian Army and Indian Air Force launched the Operation Meghdoot on 14th of April 1984, where our soldiers were taken on helicopters such as Chetak helicopters, and they were deployed there in Siachen Glacier, thus ultimately securing the strategic passes of Soltoro Ridge such as Siala, Bilafondla and Gyeonglo, etc., which gives us the coverage of this glacier, which is around 76.4 km in the length, and it provides us a strategic location from where we can keep the eye on both of our enemies here. Thus, this Operation Meghdoot marks a testimony to the selfless and the bravery services of our Indian soldiers. Keep this in mind that the army post which has been created at Siachen Glacier, it is around 18,000 feet, thus making it the world's highest battlefield in the world. We'll keep these facts in our mind and we'll move to the next segment of our news. In this particular segment, we are going to cover some important news especially curated for your prelims examination. The first of which is about Mahavir. Mahavir, who is considered as one of the most important Tirthankaras of the Jain sect. As per Digh Nikaya, he is considered to be lived around 599 to 525 BC. And he took birth at Kundalgram in Vaishali, which was in the state of Bihar. Remember that Mahavir is not considered as the founder of Jainism, rather one of the 24 Jain Tirthankaras. And his immediate predecessor, or the 23rd Tirthankara, was Parshavnath, who created Neer Granth sect. Now, at the age of 30 years, Mahavir discarded his materialistic and household life or grihast and ventured on the path of renunciation, where he actually joined this Neer Granth sect of Parshavnath. And then he took meditation and over the journey of 12 and a half years, he ultimately got enlightenment or Keval Janana or Keval Gyan at the age of 43 years at the place of Jimbhik Gram on the bank of Rijupalika river. Then he gave his first sermon at a place called as Pawa in Bihar to his immediate disciples who were 11 Gandhras. Keep this in mind that there was his chief disciple whose name was Indrabhuti Gautam. And it was Indrabhuti Gautam who led to the creation of Jain canonicals called as Angamas. And the subtext over the years which will be added will be called as Upangas. Keep this information in your mind. We move forward to the next news, which talks about INSV Tarini, which is basically an Indian naval sailing vessel. Why it has been in the news? Because it took participation in the historic transoceanic expedition of 2 months led down by the Lieutenant Commander Dilna K and Rupa A, where they took the ship alone in this particular ship and traveled or commuted across transoceanic to the Port Louis, Mauritius, and then returned back, where they did this circumnavigation sailing expedition on this particular vessel. Now we move forward to the next news, where we will talk about who are the star campaigners. Well, as per the section 77 of Representation of People Act 1951, the law relates to the expenditure which are incurred by the leaders of party, and these leaders of party are popularly called as star campaigners. So, as per the rules under the RPA 1951, if there is a recognized party, meaning a state or national party, then they can have a maximum of 40 star campaigners. However, if there is an unrecognized party, then they can have a maximum of 20 such star campaigners. Keep this in mind that the expenditure which is incurred by these star campaigners is not on travel specifically, is not included in the election expenditure of the candidate. And such maximum expenditure which a candidate can incur in Lok Sabha election is 95 lakh rupees for a large constituency and 75 lakh rupees for a smaller constituency. However, a star campaigner lodging or expenses will become the candidate's liability if the star campaigner introduces the candidate, or the star campaigner mentions the candidate's name at the rally, or the star campaigners party supporters, they attend the star campaigners rally displaying the picture of the candidate. However, if it is estimated that a star campaigner has campaigned for the candidate, the travel expenditure can become the party liability of the candidate on only the following condition. The first is that if the star campaigner shares a vehicle with the candidate to reach at the venue, in such case 50% of the cost will have to be borne by the candidate, or if the vehicle also includes helicopters. Now we move forward to the last news, which is about a large language model called as Llama 3, which has been made by a company called as Meta, which is basically the subsidiary of Facebook. And these large language models are nothing but the backbone of AI chatbots which can comprehend and generate human language text, where such large language models can lead to text generation, knowledge answering, classification of various text, translation, as well as dialogue generation. Some other example of such large language models are ChatGPT of OpenAI and Lambda of Google. Keep these important facts very dear to you for the upcoming prelims examination. And with this, we have reached to the end of our discussion today. Do not forget to attempt the questions at the end of the video and test your knowledge. We will meet in a very interesting discussion very soon. Till then, all the very best for your preparation and thank you.